Court officer? Court officer?
ಸರ್ ಹೇಳಿ ಸರ್.
Sitting later.
ಎಲ್ಲ ಬರ್ತಾರೆ ಸರ್.
ಆಮೇಲೆ ಇದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಮ್ದು ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಇದೆ.
ಪೋಸ್ಟ್ ಆಗಿದೆ ಸರ್. ಪೋಸ್ಟ್ ಆಗಿದೆ.
ಅದೇ ಯಾವಾಗ ತಗೊಳ್ತಾರೆ ಅಂತ
ತಕ್ಷಣ ಕೇಳ್ತೀನಿ. ಅದೇ ಫಸ್ಟ್ ತಗೊಂಡ್ರೆ ಅದೇ ತಗೊಂಡ್ಬಿಡಿ.
ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ ಬೇರೆ ಪೋರ್ಟಲ್ ನಂಬರ್ 9 ಅಲ್ಲೂ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಇದೆ ನನಗೆ ಎಂತ ಮಾಡೋದು ಅಂತ.
ಸಾಹೇಬ್ ಬಂದ ತಕ್ಷಣ ಕೇಳ್ತೀನಿ.
ಹೌದಾ? ಇಲ್ಲೊಂದು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಸೇರ್ತಾ ಹೋಗ್ಬೇಕು ಅದಕ್ಕೋಸ್ಕರ.
Your Lordship, we can't.
Decide it. Order it is work. What can I do? I can't wait for you endlessly, isn't it? I granted you 2 weeks time already, isn't it? Let us see, wait. Let's see. Getting stage friend. Yes.
Your Lordship, may I mention the matter? Serial number 27.
Wait, madam.
Your Lordship,
Wait.
all right. I'll wait.
Yes. Honor. ಏನಕ್ಕೆ ನೋಡೋಣ 2014 matter up to 2015 16th ನಾಳೆನಾ next week vacation ನೋಡೋಣ let us see ನೋಡೋಣ dictionaries file memo ನೋಡೋಣ yes out vacation for 45 vacation ಹೇಳಿದಾರಾ ಅಪೋಸ್ ಮಾಡ್ತಾರೆ ಬಂದವರು 52 he wants time yes or no
Your Lordship, may I now mention?
number 27
Yes, Your Lordship. Your Lordship, I'm appearing in this matter for petitioner numbers 1 to 3.
yes
Today, I'm filing a synopsis for the convenience of the court, and I'll be serving that to the other side as well, Your Lordship.
so
So, Your Lordship, I'm seeking some time because I'm filing the synopsis today.
no I don't need the synopsis if you're ready to argue I'm ready to listen
Your Lordship, I'm seeking some time
all right
beyond vacation, if that is possible, Your Lordship.
all right after vacation
I'm obliged, Your Lordship.
okay
ನಿಷ್ಕ್ರಿಯ ಜಗಸ
List number 3 will be repeated tomorrow. Tomorrow.
Vijay Kumar.
My lord, I am for the appellant in the one case and respondent in the other two cases. My lord, in the second matter, my lord, this is MFA 2605/19. Your Lordship kindly take up the judgment, my lord. Your Lordship judgment. It's a case of death of a bachelor aged about 16 years. My lord, para 16 of the judgment, your Lordship kindly see. Para 16 and 17.
50% ಮಾಡ್ಬೇಕಿತ್ತಾ?
50%.
All right.
Then, my lord, ಇಲ್ಲ ಇನ್ನೊಂದು next, my lord, in the next appeal, my lord, your Lordship may kindly see in para 30 of your Lordship judgment.
Yes.
In para 32, my lord, this honorable court has taken the age of the deceased as 40 years.
Yes.
My lord, as per their own document in para 17 of the trial court judgment.
There is a
Para
judgment of the Supreme Court, isn't it? 2015 9 SCC,
Please, my lord.
saying that it should be completed age. Have you checked up 2015 volume 9
ಅಲ್ಲ,
SCC?
40 ಈಗ now she has completed 40 years and now 40 years 10 months.
ಅಲ್ಲ, ನೀವು ಈ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದಿರಾ? 2015 ವಾಲ್ಯೂಮ್ 9 SCC page 150.
ಅಲ್ಲ, now is almost reaching 41. Up to 40 years, your Lordship may kindly appreciate, up to 40 years.
Asking you, did
It
you
is
look
40
at this judgment? ಈ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಹಂಗೆ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, ನೋಡ್ಬಿಟ್ಟೆ ಮಾಡ್ತೀನಿ.
2015 9 SCC page 150.
Please, I note down. Please, Bala, repeat. I'm sorry.
15 volume 9 SCC page 150. ಅದರಲ್ಲೂ ಈ ತರ 45 years ಪ್ಲಸ್ ಇರೋದಕ್ಕೆಲ್ಲ ಅದನ್ನೇ ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೊಂದ್ಸಲ ನೋಡಿ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಹೇಳೋದು ಸರಳ ವರ್ಮ ಕೇಸಲ್ಲಿ up to 40 years ಅಂತ. But she has crossed 40, 41 years reaching within 2 months.
ನೀವೊಂದ್ಸಲ ನೋಡ್ಬಿಟ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರೆ ಅನುಕೂಲ, ಬಿಕಾಸ್ ಇಟ್ ಲ್ಯಾವ್ ಸಮ್ ಡ್ಯಾಮೇಜ್.
Please, my lord, please, my lord. I'll do it, my lord.
Tomorrow.
But ಇದೆರಡು ಕರೆಕ್ಷನ್ ಆಗ್ಬಿಡ್ಲಿ.
ನಾಳೆ ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀನಿ. ನಾಳೆ
ಪ್ಲೀಸ್, my lord.
Appear for second respondent, Lord.
Yes.
ಇಷ್ಟು
Lead to second respondent, Lord.
ಏನದು?
Your Lordship, last week this matter was heard for some time. They told that there will some additional document appellant the reimbursement of 5 lakhs expenses ಬಗ್ಗೆ ಏನಾರ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ಅಂತ ಕೇಳಿದಕ್ಕೆ ತಗೊಂಬಂದು ಕೊಡ್ತೀನಿ ಅಂದಿದ್ರು.
ಥರ್ಸ್ಡೇ ಹಾಕೊಡ್ತೀನಿ. ವೆಡ್ನೆಸ್ಡೇ. ಥರ್ಸ್ಡೇ.
Please.
Memo for retirement is filed with the council for the petition. The last occasion, the party had appeared in person and informed the court that he would be requesting Shri Keshav Agnihotra to continue appearing for him. However, there is no appearance either the council or of the party. The above, the memo of retirement is accepted. Show the name of the appellant. and relist. Then madam, first week of June. First week of June. Direction and ಕೇಳ್ತಿದ್ರ ಅದೇ ಫೋರ್ ಬ್ರದರ್ಸ್ ಕೇಸ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ಈಗ The application for additional evidence was permitted to be produced. However, the order did not formally indicate that the application was allowed. It is made clear that the application for additional evidence was allowed by virtue of the statement made in the last two lines of paragraph 15 of the judgment. As a consequence, the registry is directed to mark these documents as exhibits in continuation of the exhibits already marked. A request is also made for return of the original documents. The office is directed to return the original documents after collecting a certificate of the same. ನಿಮ್ಮ opponent ಯಾರು? ಎಸ್ ಮೋಹನ್ ಕೃಷ್ಣನ್ ಜಗದೀಶ್ ಇಲ್ಲ
ಸಿ ಜಗದೀಶ್
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ ಬುಧವಾರ ಅವ್ರ ಒಂದ್ಸಲ ಕೇಳ್ಬಿಡಿ ಜಗದೀಶ್ ಅವ್ರು ಬರ್ತಾರ ಬರಲ್ವಾ ಅಂತ ವಾಟ್ ಇಸ್ ಎಂಟ್ರಿ ಮೋಡ್ ಗ್ರಾಂಟೆಡ್ Yes. Was filled the memo of retirement. You have entered appearance now. Since Sri Irish, he has entered appearance. So H.N. Basaraju has entered appearance for R1. Sadar D has entered appearance for R1. So Irish, Basaraju are permitted to return. In matter, madam? What is the matter? Next year. Next year, A alva. Endorsement. Your Lakshmama. Your client is Lakshmama. Imraju is your brother. You were given the right to reside in one portion. Residing there or not residing there? Case for the petition. Last time ಬರ್ಲಿಲ್ಲ ಅಲ್ವಾ ಅವರು? ಲಕ್ಷ್ಮಣ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ರೆ ಮೇಡಮ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕೊಳ್ತೀನಿ ಅವ್ರು ಬರ್ದಿರ ಡಿಸ್ಪೋಸ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ. ಏನ್ ಮಾಡ್ತೀರಾ? Madam, do you know the facts of the case? What do you propose to do? Let them go to court. He came to the court and he succeeded. So despite success, he has to lose. He came to the court and succeeded. Therefore, the person who cheated the court should be given the benefit now. Are you not supporting the employee who played this fraud? On direction, ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ? ನಾನು direction ಕೊಟ್ರೆ it will be a serious direction against the working of the housing board. You cancel the allotment, allot it to your employee, he sells the property immediately. In the pendency of the case, the property is again sold. The order of cancellation is set aside by this court, confirmed by this court, and you are now saying, no, I can't do anything, go get some other apartment. If you don't give him portion of the apartment that was given to him, you will suffer the consequences. There will be severe strictures passed on you apart from imposition of huge amounts of cost. You cannot make the court impotent. He has succeeded before the court. Your challenge to that order has failed. And there's a great degree of collusion. In the writ petition, your employee was one of the petitioners. So you think it over and let me know by Wednesday what you will do. If you give him the portion of the apartment that was cancelled, I will not do anything. If you don't, there will be a consequence. Think it over Wednesday. No, but you have taken the risk. You have taken the liability, so you will have to, there will be serious consequences, what I wanted to warn you. Wednesday. The commissioner is present as per the directions issued earlier. So release the matter on chance. The commissioner to be once again present on Wednesday. Yes. To the next area. What happened to the main criminal case in Telecast? For the offense, there's nothing, no prosecution. In ಗಾಡಿ ಏನಾಗಿದೆ ಅವಾಗ? What is the value? What is the value of? You have the option of paying the market value and then no, in case of confiscation, what is the other alternative? That you pay the market value and keep the vehicle? And what is wrong with the order? Yeah. ಎಲ್ಲೋತಿನ ಅಂಶ 2 ನ page 22. ಎಲ್ಲೋತಿರ ಅರ್ಜಿದಾರರ ಪರ ವಕೀಲರು. Who is this witness? How does the authority deal with this? Authority ಏನು ಹೇಳ್ತಾರೆ ಇದರ ಬಗ್ಗೆ? In his order, what is the consideration of this? If he has notices, how has he considered this at page 22, the last portion? ಅರ್ಜಿದಾರ ಪರ ವಕೀಲರು ಹಾಗೂ ಅರ್ಜಿದಾರರು ಹಲವಾರು ಬಾರಿ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ಸೂಚಿಸಿದರೂ ಸಹ ಗೈರುಹಾಜರಾಗಿರುತ್ತಾರೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ವಾಹನದಲ್ಲಿ ಅರಣ್ಯ ಉತ್ಪಾದನಾ ಸಾಗಿಸಿರುವುದು ಹಾಗೂ ಅರ್ಜಿದಾರರಿಗೆ ನೇರವಾಗಿ ಭಾಗಿಯಾಗಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. On what basis? In the light of this? How does he deal with this statement? ಇಲ್ಲಿ ಓದ್ತಿದ್ರ ಎಲ್ಲೋ ಓದ್ತಿದ್ರ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅಮಾನತು ಮಾಡಿ ಇಲ್ಲ ನೀವೇನೋ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ. ವಾಟ್ ಇಸ್ ದ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ದಿಸ್? ಕ್ಲೋಸ್ ಮಾಡ್ಲಾ ಇಲ್ಲ ರಿಮೈಂಡ್ ಮಾಡ್ಲಾ? No, you have not appeared there at all. Not even appeared. I reminded you an order of confiscation passed by the competent authority and which is confirmed in appeal is called in question before this court. Learned counsel for the petitioner contends that the prosecution witness himself had stated that as on the date of confiscation, there was no forest produce available in the vehicle and no person was also found in the vehicle. And yet the authority has proceeded to hold that the petitioner was guilty of transporting forest produce. And therefore the impugn order cannot be sustained. Learned AG on the other hand submits that the impugn order has been passed on a consideration of the relevant material and there is no warrant for interference with Article 226 of the Constitution. In the order passed by the competent authority, it is stated as follows, page 22. As could be seen from the above, according to the prosecution witness, at the time of the incident, there was no person apprehended in the vehicle. And more importantly, at the time of taking custody of the vehicle, there was no forest produce available in the vehicle. Nevertheless, in the reasoning portion, the officer has merely stated that from the evidence on record, it is clear that the petitioner was transporting forest produce. This reasoning is without reference to the statement of the prosecution witness. And therefore, of the view that the impugn orders passed by the competent authority as well as by the appellate authority cannot be sustained in the same recording form. The matter shall stand remanded to the competent authorities, who shall consider the matter afresh, keeping in light the deposition of the prosecution witness PW2 and then pass appropriate orders in accordance with them. Petition accordingly alone. The interim arrangement made regarding the vehicle shall continue to operate till the disposal of petitions. You don't appear in the matter is called. Repeatedly, we have to attend the matter. Then, last week, 2 or 3 matters. Who's Swathi Ashokana? You are not being present when the matter is called. What is the matter about? Next year. What is the next year? The correction then adala. Yes, madam. How can you issue a corrigendum after so many years? You can do it at any point of time. No, they are also not questioning the notification now. Notification as it stands in the measurement as mentioned, they have no issue. But how can you expand the area by issuing a corrigendum? This virtually amounts to a fresh notification. Are you empowered to issue such a corrigendum? Please show me the provision. Section 20. Which act are you reading? 95 or the old one? Section 20. Twenty-nine is powers of chief executive officer to inspect records registers. Now, what is the effect of issuing a notification? Is it not final? Notification is issued after an inquiry is conducted, isn't it? Then how can you conduct a fresh inquiry again? Where is that provision? Are you ready or not? Wednesday. In matter. Who's to recognize the course? The board or the government itself? Ayush. Wednesday. The 2011, that's why I'm not hesitant. I'll have it tomorrow then. Tomorrow. No, are you arguing or somebody else is arguing? I will pass it over then, no one. What is the matter about? Kumar is Patel or what? Pass over. Yes. You are an auction purchaser in an auction conducted at whose instance? This property was subjected to 2 mortgages and also an attachment. Who appears for the Saraswat Cooperative Bank and the Income Tax Department? Idara. Next surety is what? Madam, do you appear for the first respondent?
My lord, appearing for respondent one, yes.
What
We
is your
have filed-
contention?
We have filed our written objections already, my lord, and
When?
we will facilitate the necessary registration if as per the law, whatever decided by this honorable court.
No, was this attachment indicated in the sale notification,
No,
sale
Your-
proclamation?
no.
Why?
It was not mentioned.
Why? Why was it not done?
No, bank was not aware of it, Your Honor.
Now, before you put the property for sale, you did not seek for encumbrance.
I'll get the instruction from the.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು? How much have you paid? How much money have you paid? Where is the property? Hyderabad. When was the auction conducted, you said? You are in possession? You are in possession?
Respondent three has taken a note from respondent number one bank and area of security mortgage. Respondent three has purchased the best property. Respondent which was initiated by respondent.
You paid this amount afterwards? Scientific.
In this, the letter for the responsible is not distinct to submission and not by letter for the register and the code of submitted and responsible and they to know about the earlier transaction only after application the present. It cannot be released.
Did you say the property was sold to you? Fifteen 5/2012. This was an option under the SARFAESI Act. SARFAESI Act. Option was under the SARFAESI Act.
Yes, Your Honor.
When was the loan given to the fourth respondent? 1 minute, let me get the facts.
My lord, I don't have details just now, and it's a old matter, and I'll get back. Kindly give short date, and I'll take
Madam,
note.
this is 2011 matter, 2013 matter. I can't keep adjourning this.
A short date, Your Honor. I'll take the details from the applicant bank and then come back.
Respondent number 4 was a guarantor under this annexure D. Who's respondent number 4 here?
Sub-Registrar Vijaynagar.
No. Annexure D. This is Mohan Kumar. What has happened to this main matter? Do you have an idea? Attachment was pending disposal of the arbitration proceedings. What has happened thereafter? Do you have any idea?
The matter is posted, wait for a short time. Then we will find the statement of obvious. C of the service here.
One attachment order. Huh? Where is that income tax department?
Income tax department connection.
Was this taking order passed?
After sale of the property.
No. This attachment order was on 22/3 alva.
Income tax department is
When?
10/11/2012. Number 31.
25? Section.
46E. Notwithstanding anything contained in any other law for the time being into, after the registration of security interest, the debt any secure credit shall be priority over all other debts and all related taxes, interest and other debt payable to the central government or state government.
If it's registered. If it's registered under chapter 4A, what is the effect of the sale?
Payment. Right.
I will hear Arvind and pass orders. Let him come. Income tax department, I have not heard him. sir. Sorry? If I'll hear him once, then pass out. Pass out. You meet him, I tell him that it is passed over. He has already given an But have you preferred an appeal? You have preferred an appeal, isn't it? The stay was granted because of so for us taking possession of the movables. That's the only interim order, isn't it? Stay of the movables. Wednesday. Wednesday. Thursday is my MFA day. Wednesday. You are for the petitioner. You are for the petitioner. What is the prayer? Why is it invalid? You are? Dear. Whom do you want to implicate? Where is the application? Application for impleading the satellite town ring road planning authority is made on the ground in the pendency of this petition. The said planning authority had been constituted and it would be a necessary part. View of the above, the application is allowed and the satellite town ring road planning authority is included as the third respondent. Is there any standing counsel? Who appears for this planning authority, satellite town ring road planning authority? Please call them and find out. I'll ask the council to take notice. Or else you take notice and inform them. Shri Shivanandan AGA is directed to accept notice for the third respondent and intimate the third respondent about his appearance. If there is any other counsel empaneled on behalf of the third respondent, it will be open for the third respondent to engage him in the matter. Till his time. ಮಾಡಿ. Challenging annexure Y. One. Six one. 6-1 ಇಲ್ವಲ್ಲ, ಬರೀ 11-1 ಇದೆ. 6-1-23. ಸೆವೆನ್ ಟು ಇದೆ. ಕಾಸ್ಟ್ ಅಲ್ವಾ ಇದು? 5,000 ಕಟ್ಟಿದ್ರಂತಲ್ಲ ಲಾಸ್ಟ್ ಇಯರ್. So whether it intends to acquire the property or not. They have no proposal to acquire. But now they are making a statement that they don't intend to acquire. Now, can we issue a direction to them to issue a notification to clear the slum if they don't want to? No. See, what is the order annexure by? Shrikant, once you issue a notification under section 11, what is the next step? You are confirming the notification under section 11. Section 3 declared as slum area. There is a question of confirming a notification under section 11. Yes. It was already done in year 88. Okay. Please come to page 148. Section 3 notification was issued in year 88. Page 148. Internal page 20. Before the table. Before the table, in the instant case. So it is now declared as, it is declared as a slum area. Yes. Yes. Forget about their prayer. I want to know what is the effect of a notification under section 3 and admittedly, correct, it is declared as a slum area. So you, yes. The statutory obligation is you declare that this slum area will be cleared of the slum. Now, that is you clear the slum. Now, under page 149, it says notification under section 11 of the Act was also published as early as in the year 2003 itself. Page 149. That is internal page 21. So the notification under section 11 is already there. So therefore, there's a declaration under section 11 now. Section 3 is already there. Once it's declared as slum area, it's a slum area. Nothing else happens. It's only that the government accepts it as a slum. Under section 11, you have the power to issue a notification to clear the slum. Now that notification is now issued by virtue of this impugned order. Yes. So that is what is now done. The procedure under section 11 is initiated are now sought to be confirmed. So therefore, you are bound to clear the slum area. What have you done for the past 20 years now? Is there a stay of the slum clearance? I read at the prayer, if this writ petition is withdrawn by them tomorrow, what is your obligation under the act? Why have you not done it for the past 12 years? This order was passed when? And why did you pass the order? Now there is a statutory order to clear the slum, confirmed by the impugned order in the year 2013. What have you done for the past 10 years? Why is it that you've not done anything for the past 10 years is the question. Once you issue a notification declaring it to be an area fit to clear the slum, and if you don't take any action for 10 years, what is the effect? That is why they have come before the court, isn't it? That is the reason why the submission was made. You can acquire the land. All right, but an offer is being made. If you acquire the land, if you pay them the compensation, they're satisfied. Then clear the slum. Then clear the slum. Then clear the slum, that's all. Don't acquire it, clear the slum. Now, what is your obligation under that after section 11? See section 12. Then next is section 13. So you clear the slum area, you will utilize these two sites. This is the statutory obligation. How can you shy away from this? Now you have deprived them of the right to use the land for the past 10 years. You will have to compensate that also. Oh. The prescribed authority is supposed to enter under section 12. Under section 13. That it has done its job now. This notification is there. Section 12 casts an obligation on the owner to clear. Yes, when a slum area has been declared to be a slum clearance area under subsection 1 of section 11, the owners of the land and the buildings in that area shall clear the area and demolish all the buildings before the expiration of such period as may be prescribed. Then come to section 13. Yes. Whose job is it under the act? Why are you created then? To wash your hands off and say the government is supposed to do it? Government only declares the notification. And kindly see the rules. Rule 6, the period within which a building shall be demolished in pursuance to an order made under subsection 3 of section 9 shall be 20 days. The period for the purpose of section 12 shall be 60 days from the date of publication in the Gazette of the notification referred to in subsection 1 of section 11. Then whose mistake is it? You compensated for the 10 years loss of the property. So what? They still are the owners, isn't it? You don't dispute the title. Then you declare it as a slum area. Therefore, they cannot improve it in any way. Why are you bothered about the prayer? There is an obligation cast upon you. It is their land. By issuance of that 11 notification, you are obligated to remove the slum. And he has the right to redevelop. Why have you not done it for 10 years? If you have not done it for 10 years, then you have to compensate him for that. And further ensure that the slum is cleared. Day after tomorrow. You are again ready, right? ನೀವು ಖಾಲಿ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಇವಾಗ ಅವ್ರ ಜವಾಬ್ದಾರಿ ನೋಟಿಫಿಕೇಶನ್ ಅಂದ್ಮೇಲೆ ಆಯ್ತು ಮುಗಿತಲ್ಲ ದೇ ಕಾಂಟ್ ವೇಟ್ ಫಾರ್ ಎವ್ರಿ ಬಟ್ ಆಗಿದೆಲ್ಲ ಯು ನಾಟ್ ಚಾಲೆಂಜ್ ದಟ್ ಆರ್ಡರ್ 2013 order for confirming the notification is not challenged by you. Your party is there before the DC. Your party is there. There are about 100 odd people. Our inner Burkholder. There are 116 people, respondents. So all of you have been heard and you have not challenged this. You have accepted the slum clearance notification. Therefore, what is the effect? Section 11 notification is confirmed. You have agreed for the slum to be cleared. You are obliged to vacate within 60 days. If you don't, they get the right to enter upon the land and remove all the buildings. Thereafter, the owner of the property gets the right to redevelop. You'll have to vacate or you should persuade the government to acquire it immediately. Ilvant or Kasilvan. I will issue a direction to implement the notification. Yes. Vera? Correct, but what can you do now? You have not challenged the order. So long as that notification of slum clearance area is there, they are obliged under law to clear the slum, remove all the buildings. That's their obligation. Not necessary. They are only asking for implementation of this order to which you have acceded. ಯಾಕೆ ಅವ್ರ ಪ್ರೇಯರ್ ಮೇಲೆ ಬರ್ತೀರಾ ಎಲ್ಲರೂ? ಅಲ್ಲ, suppose they withdraw, then what happens? Second prayer is always there. Even assuming that the first one is wrong. Mr. Babi Reddy will say not pressed. Adin tumma dodada adu. You will have to clear the slum. There is no other option. That's why I think the order was passed asking whether you can acquire. Get instructions by Wednesday, or else I'll pass an order. Wednesday, Arda ಕೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ. Arda, not now, I will not permit you to challenge. ಇಲ್ಲ ಸರಿ, but it will come before this court along with this petition ತಾನೆ. By Wednesday, if you want to file it and get it before this court. Wednesday.
Yes. Because we have biggest satellite
ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ? ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಅಂತ ಹೇಳಿದ್ರಂತೆ. 10th matter. Yogesh, direct take notice on behalf of both respondents. ಅವ್ರು ಒಂದಂಗೆ ಹೇಳಿದ್ರಂಗೆ. Why did you adjourn the matter last time? Where was to what's the condition? Annexure A and C. You have paid this amount, isn't it? Annexure R5. The public sector and enterprises. You are appointed the steel authority of India. Lala. Annexure R5, which clause? Remainder period they have to work there. What is the principle? The principle is if he has joined another public sector enterprise, don't enforce the bond against him. Ensure that he serves that particular public enterprise for the remainder of the period. So how can you enforce this bond? It's not that they went to a private sector and then you got cheated. They are serving the nation through another public sector enterprise only. So then why I'll dispose of why do you require a clarification? But before me, you've taken time on 2 occasions for just this. No, whether whatever instructions they give, I think my understanding of this is clear. That so long as they appear and apply for employment to another public sector place, you really can't enforce this. Why do you want to keep this pending? Give him chance till Wednesday. If he does not have instructions, I'll discuss. What is the next G? That is clear. What did he say? After vacation, then that's it. Our Borley and Nanan. Can I dispose of the petition without their reply to this? Wednesday. Thursday is ಅಂದ್ರಲ್ಲ ಅದೇನು ಒಬ್ಬರಿಗೊಂದು ಇನ್ನೊಬ್ರಿಗೆ ಇನ್ನೊಂದು ಮಾಡ್ತಿದ್ರಂತೆ. Is it a fact for the neighboring plot you have collected 30 lakhs? You one ಜಾಸ್ತಿ ಆಯ್ತಾ 105. Then what is your answer to this allotment letter of Muneshwar Enterprises? I will ask you to apply the same principle that you have applied for Muneshwar Enterprises. Because in 2015, you allotted them at the same price, isn't it? Wednesday. I'll only ask you to follow the same. Mikitale, no, you don't have the. ಒಂದೇ ಪ್ಲಾಟ್ ತಾನೆ. When was that done? ಅದರಲ್ಲಿದೆ ಬರೀ 30 ಲಕ್ಷಕ್ಕೆ ಅಂತ. Wednesday. Annexure ಎಲ್ಲ. What is this annexure? Notification was produced. Where is that notification? Approximately 4,000 stickers and ಹಾಕಿದಾರಲ್ಲ. ಯಾವ ಸರ ನಂಬರ್ ಯಾವ ನೋಟಿಫಿಕೇಶನ್ ಸರ್ ನಂಬರ್ ಏನು ಹಾಕಿಲ್ವಲ್ಲ ಇದರಲ್ಲಿ? ಸರ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ ಅಲ್ವಾ? ಇಲ್ಲಿದೆ. ಪಿನ್ ನೋಡ್ರಲ್ಲ. This only declares the following revised boundaries of the Srinivaspur State Forest are published for general information and modification of those published under notification number so and so dated 22nd of December 1900. District Kolar, Taluk, Srinivaspura, approximate area 4060 acres. Name of the block Srinivaspura. North, south, east ಅಂತ ಹೇಳಿದ್ದಾರೆ. Where exactly have you said that this has been assigned for number 91? The total extent of this is 105 acres, out of which 87 acres is the forest. Remaining, ನಿಮ್ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು? And what is there to show that? Where is your grant order? Next year. Publicity ಇದೆಯಾ? Where is the Sagoli chit? You have a Sagoli chit? Sagoli chit produce ಮಾಡಿದ್ರೆ ಮಾಡಿಲ್ವ? What is the suit that you filed? Then shaded portion ಏನಿದ್ರಲ್ಲಿ map ಅಲ್ಲಿ? What is the shaded portion? ಇಷ್ಟಿದೆ encroached area ಅಂತ ಬರ್ದಿದ್ರಾ? Did you take action against anybody else? Where is the first order of the deputy commissioner of the range forest officer? 80. There is no finding that this 4,000 acres is relatable to survey number 91. ಇಲ್ಲ ಅಲ್ವಾ? Krishna is between this court. No, but if you are to say that this is an encroached portion, should you make an observation that there are many encroached portions and you have not taken any action? Petitioner is before this court calling in question an order passed by the Deputy Conservator of Forests on 27/9/2008, whereby it is called upon the petitioner to quit and deliver vacant possession of 6 acres of land in survey number 91 on the premise that the petitioner had encroached this land, which was a forest land. The petitioner is also calling in question the order of the appellate authority, which confirmed this order. The Private Counsel for the petitioner contends that a total extent of 6 acres of land, so number 91, had been granted to the petitioner. Yavaga? Year 1989 and 89 and 1982 and in 1999, and pursuant to the orders passed in his favor, the mutation entry was also made in respect of in his favor in respect to survey number 91, and he has been in possession ever since. The council also submits that due to an interference by the forest department, he had been constrained to institute a suit in OS 186/1994 against the state and the range forest officer. And the trial court, after trial and after considering contentions of the forest department, had proceeded to decree the suit and restrained the forest department from interfering with the possession. Therefore, submits that the lawful possession of the petitioner cannot be undone by the forest department by contending that the land in question was a forest land. Then the AG on the other hand contends that the lands in question were in fact notified way back in the year 1900 and 1910, and it cannot be disputed at this point of time that they are not forest lands. He also submits that the RTC in respect to number 91 also indicates that the total extent of the land was 105 acres, out of which 87 acres, 18 guntas, was stated to be state forest. And this entry was made in the year 2002-2003. And therefore, the argument that the land in question was a revenue land cannot be accepted. The Learned Counsel, Learned AG, has produced a copy of the notification dated 26th of July 2010. This notification states that there was an earlier notification dated 22nd of December 1900 indicating the boundaries of Srinivaspura State Forest, and the notification dated 26th of July 1910 was being published as the revised boundaries of Srinivaspura State Forest. The notification states that the land measuring 4,060, approximate area of 4,060 acres, situated in Srinivaspura Taluk of Kolar district, where the notification states, the notification gives the revised boundaries of an area measuring 4,006, approximate area of 4,060 acres in Srinivaspura Taluk and Kolar district. Notification also contains the boundaries of this extent of 4,060 acres. However, the notification does not state the extent, the fact that 87 acres of this 4,060 acres was situated in survey number 91. The authorities who have passed impugn orders have proceeded on the premise that it was not in dispute that survey number 91 was a forest land. A reading of the objections raised by the petitioner indicates that the petitioner all along contended that this was a revenue land which had been granted to him on 2 occasions. And therefore, it would be improper to contend that the land in question was a forest land. In view of the fact that there are orders of grant passed in favor of the petitioner, his assertion that the lands in this possession are not forest lands cannot be ignored. The state merely states that there's a notification of the year 1910 giving a revised boundary for a total extent of 4,060 acres. The authorities also do not indicate in which survey numbers these 4,060 acres of land are situated. The RTC which is laid upon also indicates that out of a total extent of 105 acres, 87 acres, 18 guntas is shown as state forest. The remaining is shown as Karab Neeru Munugade. This entry was made in the revenue records only in the year 2002-2003. That is after the litigation initiated by the petitioner in the year 1994. In my view, in the light of the specific ground raised by the petitioner, that he had been granted 6 acres of land by the revenue department on the assumption that it was revenue land. The authorities cannot proceed to pass an order of eviction without conducting a survey and clearly demarcating the boundaries of the forest area as notified in the year 1900 and revised in 1910. The authorities cannot unilaterally assume that the petitioner has accepted that his land is situated within a forest area. In fact, the village map which is produced, the map of Srinivasapura State Forest, which is produced, indicates that there have been encroachments over several extents of land or several survey numbers. Unless the basic question as to in which survey numbers the area of 4,060 acres are comprised in, it would be improper for the forest departments to unilaterally assume that its land has been encroached upon. That you have to matter, the impugn orders are set aside. Liberties above reserved to the forest department to conduct a survey to demarcate the 4,060 acres, approximate area of 4,060 acres, which was notified as Srinivasapura State Forest under the notification dated 26th of July 1910. If on such survey it is found that there have been encroachments, it would be appropriate, it would be open to the forest department to initiate appropriate action against the encroachers. Needless to state that the survey, if any, be conducted, shall be after notifying all the concerned parties. Decision accordingly. Chairman. What is that you have challenge here? For where was the penalty imposed?
I give my address to my office. Entry, this time what the entry got operated. Then but is imposed on David's name. If your receipts are booked, but they have imposed that. And all is considered all across India, there was
Sir, license conditions of conduct
Is it a fact that the matters are pending before the Supreme Court? The same issue as to whether the scheme is valid or invalid.
They have to they they in order and they what don't want to just because the matter is sitting. This issue is no part.
This is given a bank guarantee, isn't it? Do they have an interim order here? Do they have an interim order here?
But that is not the problem is every time, saying that for that matter is job. And there is no say, it is big that is not there. There are some confusion at left and it has been there.
You are challenging the conditions imposed in your license.
License will have, you cannot consider that, once they are paying you.
Yes. The first prayer is to quash these demands. Second one is to declare that the penalty cannot be levied. The third prayer is to quash and set aside clause 5.1 and 10.21 of the license agreement. So once you agree for a license agreement, can you now turn around and say that the condition is bad? This is a contract, isn't it? Leonard, he says the matter has been. These are all interim orders. Is there any final order? Is he right? Is he right in saying that the Tripura High Court has upheld this notification? That may be so, but
Page 7 at 9. Page 7 word in the order of
yes.
the third senior counsel for a particular next, according to the order agents also, there it is agreed with the party. It's simple issues.
If you see the last portion of the order, there's a advice given by you to move the Supreme Court by way of a transfer petition. No, at the parties would be well advised. So you have also not chosen to. Maybe so, but none of you have gone and sought for a transfer. So you might as well go on with the matter and finish one way or the other. But now the petition is pending for nearly 10 years now. For how long do you want us to continue? If you had sought for a transfer petition, I would have. Let me not repeat the same mistake because nobody is trying to take up and dispose of the matter. But for 10 years, Mr. Ola, they have been waiting. Let's at least get a disposal. You can also take it up to Supreme Court one way or the other, or they may take it up to Supreme Court. They succeed. But for 10 years, you've had the benefit, isn't it? I think. No, it can always be subject to you'll get a refund if you succeed. It's not that your money will be. True, I understand, but there's nothing that will happen if you pay the penalty. You'll always get the money back. It's a question of book adjustment if you ultimately succeed. Because I have my doubts as to I have my doubts whether you have right to now challenge the license agreement. After you. I am ready to hear the matter. Leonard Senior Counsel wants time. I am ready to hear the matter. Leonard Senior Counsel wants time. Last week of vacation, sir. Who can I direct? Every time you allowed the matter to be adjourned, so. Released after vacation. What is annexure W and W1? By whom? And you are not ST.
Lord, may I make a mention, my Lord? Appear for C Jagdish, my Lord, kindly pass on.
He wants a passover. What do you want me to do? After vacation class unna? After vacation. Thank you. Edward time ಕೊಟ್ಟಿದೆ ಅಲ್ವಾ? So. After vacation. Who's opposing you? Permanent local Adala. But 17 page ಆರ್ಡರ್ ಬರೆದಿದ್ದಾರೆ. ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಏನ್ ನಿಮ್ದು? $24 lakh telephone bill.
Inclusion error being local also. Now I have respected we must be wrong. They themselves
Where is it shown that you have not given an not given an option? What is the issue that he had not appeared? Order layer ಬರ್ದಿದ್ರಾ he was absent. Okay. What documents? What was their defense? What is the complaint?
Because it's just in the this is the because the themselves are active as a language.
ನೀವು ಡ್ರೆಸ್ ಇದೇನೋ ಡೆಸ್ಕ್ ವರ್ಕರ್ ಆಗಿ 2 ಫೋನ್ ತಗೊಂಡಿದ್ರ ಏನಿಗೆ ಬೇಕಿತ್ತು 2 ಫೋನ್ ನಿಮ್ಗೆ? Did you require 2 phones? What is the difference? You ತಗೊಂಡೇ ಇಲ್ಲ connection ತಗೊಂಡೇ ಇಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ರ. That was your condition that you had not taken. Then what? Now, what is your conduct? You first say that connection ತಗೊಂಡಿಲ್ಲ ಅಂತ. Then if you had simply said that somebody had done this, I can accept. ನೀವು ಆತರ how can they occupy your house? How can they you be paying rent to them somebody? If you can keep the house vacant for so many months and years. Contact ನಂಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. Your contention all along was that nan phone connection ತಗೊಂಡಿಲ್ಲ ಅಂತ. That contention indicates that you are not really contention ಪೂರ್ತಿ ಅದು forgery ಅದು ಇದು ಅಂತೆಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು ನೀವೀಗ that is a contention advance, isn't it?
But the
ಎಂಟ್ರಿ ಮಾಡಿರ್ತೆ ನಿಮ್ಗೆ. ಇನ್ ಸ್ವಲ್ಪ ಫರ್ದರ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ನಿಮ್ಗೆ ಹೆಂಗಿದ್ರೆ ಇವಾಗ ಯು ಗಾಟ್ 10 years of breathing time. But still 24 lakhs, you now admit that you have taken 2 telephone connections. But now Angar Bidi, they will not recover it. Why do you want to go contest? No, for remand for what? You can't. In a 3 lakhs deposit ಮಾಡಿ, ಇನ್ನು 3 lakhs deposit ಮಾಡಿ remand ಮಾಡ್ತೀನಿ. Let him arrange, because his conduct is not right. He said he went to the extent of saying that I have not signed the application for the phone connection. ಆಯ್ತು, ಅದ್ 3 ಲಕ್ಷ ಆಯ್ತು. 24 ಲಕ್ಷದಲ್ಲಿ 6 ಲಕ್ಷ ಕೊಟ್ಟಂಗ ಆಗೈತೆ ಅಷ್ಟೇ. ನನ್ನ ಪ್ರಕಾರ ಅಷ್ಟೇ ಲಾಸ್ಟ್ ಬರೋದು. Correct, but you make a deposit. Show your bona fides. Government will simply dismiss it. I don't think they'll be able to recover this 24 lakhs. You make some deposit. Two lakhs ಮಾಡಿ. 2 lakhs, 5 ಆಗುತ್ತೆ. The petitioner calls in question an order passed by the permanent law gatherer, by which the claim of BSNL has been accepted and the respondent is directed to pay a sum of rupees 24,76,020 in a period of 3 months. It is the contention of the petitioner that though he had engaged a counsel, objections are also filed. There was no participation at all by the counsel before the permanent law gatherer, and the order that is passed is virtually an ex parte order. It is therefore prayed that the matter may be remanded to the permanent law gatherer and an opportunity be provided to the petitioner to establish this case. Though the order passed with the permanent law gatherer does not indicate the non-participation of the advocate. So, however, since there is nothing on record to indicate that the petitioner or his counsel have appeared in person and argued the matter, in my view, it would be appropriate to set aside the order and remand the matter to the permanent law gatherer. The direction to the permanent law gatherer to reconsider the matter afresh after giving an opportunity to the petitioner. So the petitioner had the benefit of an interim order for this court, subject to paying a sum of rupees 3 lakhs. In my view, he said interim order shall continue to dispose of the proceedings with the permanent local adalat, subject over to the petitioner depositing a further sum rupees 2 lakhs within a period of 1 month from today. If this sum rupees 2 lakhs is not paid, this order shall stand recalled, and the order of the permanent local adalat passed earlier shall stand confirmed. So the petitioner to appear before the permanent local adalat on date. Somebody is appearing in person? You are the golf association. You are the golf association. What is your contention? You are a society registered under the. Are you reading? Are you reading? 24. But this was granted initially at 1 rupee per acre.
Annual cost. This one of the policy.
This amounts to a substantial financing, isn't it? Because your entire basis for running the association, the golf association, is the land. If this is given to you at a highly subsidized cost,
That's cost.
you mean to say that
Which is like the government of the city.
they've also said that 50% depends on the amount of contribution. But here for running the golf association, the land is the fundamental requirement. And if that is given to you at just 2% of your revenue in the city of Bangalore, 124 acres, you're saying it's not.
May not be, because you can't feel anything on it. So life expectancy solution, that is the value. Which is what the government has taken into. There is a time where you cannot.
No, what use that land can be put into is different. But to say that the land, that this is not substantial financing is a bit surprising, isn't it? No. What is it? He's only seeking for information. That information is granted or refused.
Because we have saying that we are not a public. He makes a complaint before the information comes.
He says it's a public authority.
He said that. He set certain amounts. I said this is the rent that they are paying, which is not fair. Those amounts are incorrect. My own account statement show that I paid for.
Even according to as per this page 24, this entire land on which your golf association is dependent on is given to you only on 2% of your annual gross income. So therefore, suppose you do not have an income for the next year, you pay nothing. If you don't have any income, that's a different thing. This amounts to pointing to the fact that it is substantially financed, or to put it differently, heavily subsidized.
That may not be the only test. Because
what are the tests?
We have taken 37 lakhs. There There are some roads we have been paying, I think, so far, like 18 roads. But I don't know the gate of
But you're enjoying 124 acres, so it's not like as if you're giving some throwaway amount to them. And the 7 crores will not really impress anybody if you're sitting on 124 acres. That we don't know, they may give it to some other golf association and they may get a higher income. Isn't it? It's not that the land can't be put to use. What is information sought for? Where is the order?
Just ask the minister if he buys some material, you can always ask the KSTD. You can ask the government. After getting a list of members, none of them that you can get for.
Whatever information he wants, we just have to give him, that's all, isn't it?
You are not safe for information. Your question to us. That know the index that's required.
But he wants you to follow the act, isn't it? The act mandates that you have that cataloging index. I think the order is right. I don't think there's anything wrong in this order. Yes. No, even if I accept your contention, it is 2%. I would still feel that it is a public authority because it is quite heavily subsidized. Yes. Where is your judgment for the golf club and is it a fact? This court has taken. This court upheld the fact that it's a public authority. I'll simply follow this. You take it up in an appeal. That's all. It's all the same, isn't it?
Even this matter was tagged along with the card. Even the patient came to be tagged.
Tough club, guy. This is tough club.
There were actually four clubs which were responsible. We beach club and and in all those clubs, my lord, what
Follow this. It is not in dispute that this matter had already been clubbed along with WP numbers 18449 by 2015, which was connected with WP 38347 by 2013, 58192 by 2013, 8053 by 2015, and 22774 by 2015, wherein the principal contention considered by the coordinate bench was as to whether societies registered under the Societies Registration Act, such as the Bangalore Turf Club, the Bangalore Turf Club, the Mysore Race Club, Ladies Club, and the Institution of Engineers, which were granted lands on the basis of a lease by the government, could be considered as a public authority, since the grant of lands under lease amounted to the petitioners therein being substantially financed, so as to bring them within the purview of the RTA Act. This court, by a judgment dated 13th of January 2021, upheld the finding recorded by the Karnataka Information Commission that those institutions were indeed public authorities, and the provisions of the RTA Act would therefore be applied to them. In this case, the petitioner is the Karnataka Golf Association, which is running a golf course on the basis of the land leased to it. The government order which is produced along with this petition indicates that 124 acres of land has been leased to the petitioner association for a period of 30 years from 17th of May 2010, subject to the petitioner association paying 2% of their annual gross income as lease. This is for the same period. In my view, the fact that 124 acres of land has been leased on 2% of the annual gross income would indicate that the association has been substantially financed by the state. It is to be noticed here that the golf association can run the golf course only if the land is available to them, and if the land is given to them on a heavily subsidized rent, this would amount to a substantial financing as contemplated under the RTA Act. In my view, therefore, it would be appropriate to follow the decision rendered the aforementioned writ petitions and uphold the order of the Information Commission. The writ petition is therefore dismissed. Enter R. Same ಅದೇನ ಶ್ರೀನಿವಾಸಪುರನ ಸೇಮ್ ಶ್ರೀನಿವಾಸಪುರ ಇಲ್ಲೇನಾಗಿತ್ತು There is a reasoning. Notice there to show that this is forest land again. Survey was conducted after hearing him. ಸರ್ವೆಗೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರಾ? ಅವ್ರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರೆ ನಿಮ್ಮಷ್ಟು ನೀವೇ ಸರ್ವೆ ಮಾಡೋದು ತಪ್ಪಾಗತ್ತಲ್ಲ. Do they admit the survey in the writ petition? ನಿಮ್ಮಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ ಅವರು? ಒರಿಜಿನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ there is original order. I don't think they've been heard in the matter. Consider our notice ಕೊಟ್ಟು ಆಮೇಲೆ ಮಾಡಿ. An order of eviction passed by the Deputy Conservator of Forest and affirmed in appeal is called in question. This writ petition. The impugned orders indicate that a survey was conducted in November 2007 to identify the encroachment into forest land, and Panchnama was drawn, the presence of Panchayat Dars, and the encroachment was identified. It is therefore concluded that the land in question is a forest land, and the petitioners have no right to be in possession of this land, even if the lands are alleged to have been granted to them by the Revenue Department. A reading of the impugned order does not indicate that the petitioners who are alleged to be encroachers were intimated about the intending survey and that they participated in the survey proceedings. In my view, a survey conducted in the absence of the petitioners who claim to be in possession under the orders of a grant cannot be the basis for an order of eviction. The impugned orders are therefore set aside, and the matter stands remitted to the third respondent, who shall be at liberty to conduct a fresh survey after notifying the petitioner and thereafter proceed to pass appropriate orders in accordance with the petitioner recording. What is the matter about? ಇಲ್ವಾ ಅವ್ರ ಸರ್ವೆ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ರಾ? I will challenge that survey. Then Spy and Raghunath's case. ಹಿರೇಮಠ್ರೆ
ಶಿವಪ್ರಭು ಹಿರೇಮಠ್
this is not challenging an appeal. This is Raghunath. ಹಿರೇಮಠ್ರೆ ಹೇಳ್ತೀರಾ ಅವ್ರಿಗೆ? I'm going to pass it over or ಹೇಳಿ ಮಧ್ಯಾಹ್ನ ಹೇಳಿದ್ರೆ he agrees that it is covered, I'll dispose it of or else. Who are you? No. What is your designation? Were you the information officer? What is the order cost? 25,000. You only agreed with the penalty. Show me now is information provided. When was the application filed for seeking for information? I need the basic facts. When did the application seeking for information made by the applicant? That's section G. 15.3. Where is that annexure? You are the director.
No, I was not the director. I responded. Right. He's strikes. It's a. I'm sorry.
Annexure G was given to
Public information officer.
action taken for the letter dated 27/12/2000 and file noting. Was information provided?
Stated in my. Oh.
Did you was this applicant informed about that?
He was informed.
When?
He was informed by me.
When the application was addressed to the director on in the application at 15/3/2013. You were asked to provide that information by the director. What was your reply? When did you give the reply? Then what happened?
Well, subsequent to receipt of this information. We dated 27/2013.
That is internal appeal, first appeal.
That's the first one. This is an action N. Page 47. The bill itself is dated.
What happened to the first appeal?
This first happened this order. Dated 9/7/2013. This is on page 1. Folders. Connection to this matter, the PIO has stated that the information has been. It's the responsibility of the department.
So is a third party information that was sought for?
It's not that part of it. It's personal information. It has instructions. The head of the department. Total outcome.
Then second appeal?
Second appeal, it was held, which is the appeal order, section A, operative part is page 24, the English translation is page 29, paragraph E. So, paragraph E. Saying that the respondent.
Where was the letter dated 25/3/2013 of the director? That is your response, isn't it? 27/3. What was the letter given to you?
Stating that there is no information.
But you did not choose to inform the applicant.
It was informed.
Then,
Informed the concept.
if you had been informed, you would not have preferred an appeal, isn't it?
He was informed despite that information.
What is there to show that he was informed pursuant to your letter dated 27/3/2013?
It was written by.
Because if the director had simply asked you to furnish information,
It was written by that's a connection A, which was in 2015.
Measure K.
Regarding the information requested to matter of transfer.
He has furnished information available to him on 25th of March. No, he has, kindly see the letter. It's addressed to some Anjum, Sarojanika Mahiti Adhikari.
He will transfer the application to him, provide the information.
Is he the designated information officer?
The application for.
Where is that transfer? Asking, that's why I said, where is the letter dated? No, by the letter dated 25/3/2013. If he was asked to furnish the information to the applicant. Correct.
20th is Shahutta Anjo application to the district here.
Was it with the direction to him to furnish the information? Where is that?
The next document to the endorsement. This is by Mr. Shahutta Anjo, who will instruct him saying that you cannot write the letter to me, furnish the information to the applicant. Because that was never informed to the applicant. Lot of ಮೇಲಿನ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಡುಪಿ ಬೆಳೆಗಳ ಬೆಂಗಳೂರು ಸೋಲು ಮಾಹಿತಿ ಸಂಯೋಗ ವಿಭಾಗಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ನಾಟಕ ಆಗಿರುತ್ತದೆ ಹಾಗೂ ಆರ್ಟಿಐನ 6 ಕ್ಲಾಸ್ 3 ಪ್ರಕಾರ ತಮಗೆ ವರ್ಗಾಯಿಸಲಾಗಿದೆ. ಅರ್ಜಿದಾರರಿಗೆ ಮಾಹಿತಿಯನ್ನು ನೇರವಾಗಿ ಒದಗಿಸಬೇಕಾಗಿದೆ. ಆದ್ದರಿಂದ ಸಂಬಂಧಿಸಿದ ಮಾಹಿತಿ ಬಗ್ಗೆ ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಕಳಿಸಲಾಗಿದೆ. Now my lord, the candidate election day, which is the letter again my lord by Chavita and was the original PIO to the applicant. You only inform saying that the application is transferred to the registrar hearing. Therefore, all the info will be given to you. And in fact, it is incorrect because the information
And is only agreed by the imposition of penalty, so I'll confine myself. Just answer my question. On 27th of March 2013, you gave a reply saying that you do not have that information. Please. Now thereafter, this lady or gentleman, Anjuman. Now she addressed a letter to you on the 17th of April, saying that it's your responsibility to furnish information to the applicant. Correct? Did you give a reply to the 17/4/2013 saying that you are not the PIO and therefore you are not obliged to give the information? Not answering my question. You are not answering my question. Not answering my question. Did you give a reply to this lady saying that you are not the PIO and you are not obliged to furnish information? That is why penalty has been imposed upon you. That is information.
There is no information.
That is information.
That is the information. Since there is no information, I provided it to the concerned authority.
When that concerned authority asked you to furnish information directly to the applicant, what prevented you from giving that applicant the same letter? Nobody is saying you the PIO. The PIO informed you that it's your obligation under the act to furnish information directly. Did you respond saying that it is not my obligation? That is besides the point. The penalty is imposed on you because you failed to furnish information. That is the allegation against you. My simple question is, when the PIO asked you to furnish information directly, did you have the courtesy of informing him that I cannot do so because I am not the designated information officer? You please do. Did you inform that? There's nothing on record. I'll dismiss it.
There is no information.
You are not to judge as to why the application is made for. If that does not lie in the that is not why penalty is imposed on you. Did you take up this stand when the letter was addressed to you? Continue at 2:30. I don't think there's anything. 2:30. I thought if you argued saying it was a mistake, I would reduce the penalty to 10,000 and close it. But since you're arguing that you're not the PIO, you will suffer the consequence. 2:30. Last time also there was no appearance after vacation. Yes. Enough.
After appearing without the yes, for the area the earlier before the formation of the layout, what was the structure of the property in that village level? It has proper the report of the area that has not been come take care of.
Copies for the petition. Chair Madla. Next ತರ್ತೀರಾ? Rakesh. 38. 2014 ನೋಡೋಣ ಇರ್ರಿ. 2014. Wednesday. Who took a passover in this case? Even I have permitted you to retire because there was no appearance. I have permitted you to retire because there was no appearance. He had. It was listed when the matter was called, there was no appearance. Therefore, I permitted you to retire. Realist on that. All right.
Court officer.
Court officer.
Court officer.
Court officer. Court officer.
The number you're calling is currently switched off. Please try later.
ಊಟ ಮಾಡ್ತಿದ್ದೀರಾ ಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್. ಇವರೇ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇಲ್ವಾ? ಊಟ ಮಾಡ್ತಿದ್ದಾರಾ?
ಅವರು ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ, ಬರ್ತಾರೆ.
ಹೌದಾ? ಏನಿಲ್ಲ, ಡೇಟ್ ಹೋಗಿದೆ ಕೇಳ್ಬೇಕು. ಸೀರಿಯಲ್ ನಂಬರ್ 32. ಊಟ ಮಾಡ್ತೀರಾ? ಡಿಸ್ಟರ್ಬ್ ಮಾಡಲ್ಲ.
ಇಲ್ಲ ಅದೇ
ನೀವನ್ನ ರೆಸ್ಪಾನ್ಸ್ ಮಾಡ್ತಿರಲ್ಲ, ಖುಷಿ ಆಗುತ್ತೆ ನಮ್ಗೆ.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
Serial number 37, sir.
ಇದೆ.
ಸರ್
Thank you.
32 ಸರ್
ಅಲ್ಲ ಇದೆ ಇದೆ
32 ನಾನು ಕೇಳ್ತಿರೋದು.
32 ಇದೆ.
ಹೌದಾ? ಸರಿ ಸರ್, ಸರಿ.
I agree with everything that you say. Did you respond to that effect? When? Why did you give the information back to her? If you had said, you are nobody to ask me, I will not give you any information. You respond by saying that that information is unavailable to you. Then you get a letter, furnishes information directly to the applicant. Forget about her conduct. We are concerned with your conduct. You are the one who has been now burdened with the liability to pay a penalty. My impression is that you chose to ignore the order of the SPIO. Kindly come to your reply. Let us see how you address the letter to us. Next H is your reply. Kindly see the designation that you have given her. No. Next H. Shagupta Anjum, Sarvajanika Mahiti Adhikari. You have accepted that fact. Something wrong impression. Why did you? Here again, you're trying to just. Then when she gave a. What is your stand? Yes. From the day one, Stella. ಅದೇ ಪೆನಲ್ಟಿ ಹಾಕದ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತು ಅವ್ರಿಗೆ ತೊಂದ್ರೆ ಏನಾಗತ್ತೆ ಅಂತ. You want the that's why I told him, if he had said that, I would have reduced the ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದ್ರಲ್ಲಿ 20 ಸಲ this defense of yours kind of encourages me to affirm the order, because it's not ಇರ್ಲಿ, ಅದು 25,000 ರೂಪಾಯಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಯ್ತು. ಆಯ್ತು, ಎಷ್ಟಾಕ್ಲಿ ನೀವ್ ಹೇಳಿ, ಎಷ್ಟಾಕಿ? 25,000 ಬೇಡ, ಎಷ್ಟಾಕ್ಲಿ ಹೇಳಿ. I'm picking your advice. How much should I order? You argue on merits, it's going to be 25,000. All right, then 25,000. And 25,000, that is all. If you want to argue on merits, you'll get an order on merits with 25,000. Probably in addition to 25, that is already imposed. I think I have far more important matters to deal with than a request for certain information was made by the sixth respondent to the fifth respondent, and the fifth respondent in turn sought for information from the petitioner. The petitioner in reply furnished the information on 27/3/2013 to the effect that the information sought for was not available. It is not in dispute that thereafter the fifth respondent addressed one more communication dated 18/4/2017, 17/4/2013, by annexure J, directing the petitioner to furnish this information to the applicant. However, the petitioner chose not to abide by this communication. Ultimately, on 18th of April 2013, the respondent directed the applicant to contact the petitioner if further information was needed. Next, the applicant thereafter preferred an appeal, and the appellate authority passed an order on 9/7/2013, holding that the petitioner had already been, the applicant had already been furnished with the information, and therefore the proceedings were closed. The applicant thereafter preferred a second appeal. The second appellate authority, by his order dated 20th of September 2014, confirmed the order of the first appellate authority. The second appellate authority directed the information, the state SPIO to furnish the information sought for. In addition to the said order, a further order was passed directing the petitioner to pay a sum of rupees 25,000 as costs to the applicant. The petitioner being agreed by this imposition of penalty is before this court by way of this writ petition. Learned counsel for the petitioner sought to contend that the petitioner was not designated as the SPIO and therefore no penalty could have been imposed on him. It was also stated that the information sought for had been furnished to the SPIO and therefore the obligation, if any, stood discharged. Next paragraph. It is to be noticed here that the petitioner did furnish the information sought for by his communication dated 27/3/2013. However, it is also noticed that despite a specific order being passed, despite a specific communication dated 17th of April 2013, directing the petitioner to furnish the information to the applicant directly, the petitioner chose not to abide by this said order. The arguments that are now advanced are more in the nature of technicalities so as to justify the non-compliance of the communication dated 17/4/2013. This indicates that the petitioner, instead of furnishing the information sought for, sought to take up technical stands, and this virtually amounts to depriving of the applicant the right to secure the information that is guaranteed under this act, under the act. Or it is also noticed that since the petitioner did furnish the information, albeit to the fifth respondent instead of the applicant, the imposition of rupees 25,000 as cost would be excessive. In my view, it would be appropriate, therefore, to reduce the penalty imposed to rupees 10,000. Writ petition is accordingly allowed in part. Even Teacher is calling in question the communication dated 19/1/2012. Actually, to the extent that it has been stated therein that the petitioner has no right over the trees situated on the land which has been felled. It is not in dispute that the land in question is a Paradina land, and in respect of similar cases, this court in the case of Y.N. Raghunath versus the Chief Conservator of Forest, WP 4974 of 2015, has held as follows. Page number 8. It is also not in dispute that this decision has been affirmed by the division bench, and the ratio laid on in that decision is also followed in WP 16289 by 2022. The right of the fact that the contention raised in this writ petition are covered by the aforementioned decision. The writ petition would have to be disposed of by directing the respondents to refund the amount where refund the amount sought for %12 interest. In view of the fact that the division bench has also awarded interest on 12 at the rate of 12% on similar amounts which is the subject matter in case of Y.N. Raghunath, the petition will also be entitled to interest at the rate of 12% on sum of rupees 1,80,11,600. The petition according to the 40th ಏನಂದ್ರೆ the concerned respondents are directed to ensure that the money as ordered to be refunded above shall be made before on or before 3 months. 3 months. 1 ಕೋಟಿ ಕೊಡ್ಬೇಕಲ್ಲ, ಈಗ ಎಲೆಕ್ಷನ್ ಬೇರೆ ಬಂತು ಇನ್ನೊಂದು ತಿಂಗಳು ಏನಾಗಲ್ಲ. 40 ಅದೇನಾ? Next. Wednesday. Take objection ಬೇಕಾ? ಅಲ್ಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕಲ್ವಾ ನೀವು ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಒಂದು 173. But your prayer indicates a charge sheet is already filed, isn't it? Once a charge sheet is filed. Correct, no, but 173. If the charge sheet is already filed. And 173.8, the further investigation can be sought for, provided you grant the leave of the session judge. The power of this court, that's all right. But since you have a remedy, if you feel the investigation is to be done further, make an application to 173.8 there. No, for that if you need to make an application seeking for transfer of the case on whatever grounds. But how can you? What happened to this complaint that you gave against the fourth respondent? What is the stage here, darling? You know what is the stage? The fact that they have investigated and laid a charge sheet indicates that I'm only concerned because he's making an allegation against presiding officer. Find out what has happened to the scenarios on Wednesday. Objections ಹಾಕಿದ್ರೆ ನೀವು 5 objections ಹಾಕಿದ್ರಾ Wednesday arrived on Wednesday, find out. They challenge the Karnataka Nursing and Paramedical Services Regulation Authority Act. ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ಕೇಳಲ್ಲ. Okay, somebody asked for time in this matter.
My lord, serial number 31, my lord.
Yes.
Appear for the petitioner, my lord. My lord, we are retiring from the matter. We are unable to get in touch with the client.
He wants to retire. Vacation.
Serial number 32, I am appearing for respondent number 1.
Yes. ಏನಾಯ್ತು?
ಅದು BPMP ಅವ್ರ ಹತ್ರನೇ ಇದೆ ಸ್ವಾಮಿ. ಅದು ಇದೆಲ್ಲಾನು ರೆಕಾರ್ಡ್ ಎಲ್ಲ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲವಂತೆ, ಫೈಲ್ ಮಿಸ್ ಆಗಿದೆ ಅಂತಂದ್ರು.
ಕಂಪಲ್ಷನ್ ಕೊಡ್ತೀರಿ ನೀವೇ?
ಇಲ್ಲ, ನನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ತಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಯಾವ ತರ
ನಿಮ್ ಸ್ಕೀಮ್ ಕಾರ್ಡ್ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಕಾಸು?
1.5 5 lakhs ಇಂದ 2 lakhs ಬರುತ್ತೆ.
ಎಲ್ಲಿದೆ ಸ್ಕೀಮು?
ಸ್ಕೀಮ್ ನಾನು ಹಾಕಿಲ್ಲ, ಬಟ್ ಅದು ಅಷ್ಟೇ ಇರೋದು ಎಲ್ಲ ಇದ್ರಲ್ಲೂ ಅದೇ ತರ. ಆಕ್ಚುಲಿ ನಂಗೆ ಕೊಡೋಂಗಿದ್ರೆ ಅದನ್ನೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು. ಆಕ್ಚುಲಿ ಅವ್ರು ನಮ್ಗೆ ದುಡ್ಡು ಕೊಡ್ತಾರೆ, ಕರೆಂಟ್ ತಗೊಂತಾರೆ BBMP-ನವರು. ಅವ್ರು ನಮ್ಮ ಕನ್ಸ್ಯೂಮರ್ ಅಂತಾನೆ ತಮ್ಮ ಮುಂದೆ ನನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರೋದು. BBMP ಫುಲ್ ಹೈಡ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ಅಷ್ಟು ಮಾತ್ರ ಹೇಳ್ಬನ್ನಿ.
Inspector report is electrical inspector report.
Document number 2.
dalle ಅಭಿಪ್ರಾಯ ಇವತ್ತ
ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ಮ ಸ್ಕೀಮ್ ಪ್ರಕಾರ
1.5 to 2 lakhs, my lord.
1.52 ಅಂದ್ರೆ ಏನು ಹೆಂಗೆ ಡಿಫ್ರೆನ್ಸ್ ಏನು 1.5 2
2 maximum, 1.5 minimum. ಅವ್ರು ಯಾಕೆಂದ್ರೆ ಅವ್ರು ಬರೀ
No, you go to the civil court and obtain the remaining. ಏನಂತ
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋದ್ರೆ ಅದು ಬರಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕೆಂದ್ರೆ ಅವರು
For that I have to give a determination as to who is at fault. I have to give a determination as to who is at fault, which requires evidence. Both of them don't admit.
ಹೌದು
The occurrence of the death is not in dispute, but who's responsible is being disputed.
No, that is also not the case. There is a question that principal as to that is the law.
It is the civil court jurisdiction, not under 226.
No. Further,
BBMP says it was a duty of the BESCOM to have maintained this. BESCOM says the duty of BBMP to maintain this.
my submission, my lord.
No, if there is a contract which permits you to install the street lights and you are given the responsibility of maintaining that, if this
Yes,
accident
yes.
has, because as a reason of the wrongful maintenance of the street lights, you also would be responsible. The agreement is not, therefore both of you go face this music in the civil court.
Yes, my lord, that is.
As of now, I will grant 2 lakhs, which according to the scheme, any person being electrocuted would get 2 lakhs. Remaining, let him go to the civil court and decide. After vacation.
Yes. My humble submission, my lord. In this writ petition, that is 16 and 58 of 2019.
I was prepared to get him 2 lakhs and then allow him to go to civil court. He wants the entire amount here only.
ಅಲ್ಲ ನಾನು ಕೊಡೋದಿಲ್ಲ, BBMP ಕೊಡಿ, ನಾನು ಕೊಡ್ಲಿ.
Next M. What is the next M? So this solar panel was outside your house. Where? Where is the technical approval? No, this is not after the spot inspection. This is your application was approved. Where is the technical after that you? No, after you should you give a plan for this and get their approval?
ಇಲ್ಲ ನಾಡಕ ರಜೆ ಇಲ್ಲ.
Which is this policy 78/2016? In this annex M, there is a reference to the 17/8/2016. ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ನಂಬರ್ so and so. ದಿನಾಂಕ 17/8/2016 Where is that? Let us see the policy under which you annexure C, na? You're not given her a copy. This is 2016 and you're saying you still don't have copy. When was the approval granted to you? 2016. Age? Local authorities ಬೇರೆ ಇವ್ರ ಹತ್ರ ಕೊಡ್ಬೇಕಾ ನೀವು? Solar rooftop ಏನ? This was in cancellation of an agreement, isn't it? ಇಲ್ಲಿ follow this. No. You can take up this also in appeal along with that. The petitioner, the petitioner is calling in question. For what? You already connected to the grid. You already connected to the grid, you are paying him 90%. This government order that you rely upon is issued subsequent to this approval granted to him. Yes. In reality, you only purchased land. So who owns the apartment? Oh, where do you put that? You had purchased an undivided interest in the land. In which portion of the undivided interest can you put up a structure? No, all right. But now that you are undivided owner, which portion of the undivided interest can you put up the apartment? Portion of that undivided interest. Can you put up the? Then you are essentially buying the apartment. It's only a ruse to get over the stamp. There's an article under the Stamp Act, isn't it, under schedule for such a specific purpose. So that cannot be the analogy because there's a separate provision for stamp duty insofar as there's a lease cum sale agreement provision. Even then that article was there. What is that you have challenged here? Is the next area. It's referred under 45A. It's the reference under 45A, isn't it? Where is your sale deed? You wanted registered. Yes. So long as you want schedule B, no, you can delete that. Because according to you, schedule B was constructed by you independently. So there was no question of those ladies conveying it to you. Then why do you want schedule B? No. That is what gives him the right to seek for. No, you give up schedule B and they'll probably, you give up schedule B. No, that's what you have said. That's what this. Page 59, the purchasers are entitled to exclusive possession and enjoyment of the schedule B property together with right of use of the specified car parking space in the basement of the said building with exclusive right to use the earmarked garden space subject to the terms and conditions contained here. No, the schedule B property. You give up schedule B so that you will only say that you're buying an undivided interest, then they'll reconsider. So long as you have schedule B by which the apartment is sought to be transferred. But you are giving them the right to use exclusively. What else is it? The purchasers are entitled to exclusive use. This is what the vendors are saying. The purchaser shall have exclusive use of schedule B property. You will delete all this and you simply say I'm buying undivided interest, then they'll only calculate on that. You will not get title over the apartment. That can't work. This is a ruse to get over this time. That cannot have no application because a specific article mentioned in the SAMPAC schedule in respect of lease cum sale agreements. So therefore, you can't take that as an analogy. Schedule A, undivided interest, I have no problem. If you include schedule B, then there's a problem. No. Entitled to exclusive possession of not only just schedule B, of the garden space and the parking. So it is just not the undivided interest. It's a right to enjoy the property, which is specified, which has a value. I am with you on that. Suppose the sale it simply said, I am selling you undivided interest of let's say 2%, 3%. 3% of the land value they will calculate and collect. If the sale it is only to that effect, maybe you have a point. But the moment you include that I have constructed an apartment and that apartment is also sought to be a subject matter of this particular deed, then there's a problem. Then give it up. Why do you want it? Redo the sale deed. Tell them that you're just buying undivided interest in that particular property. Then they will see where exactly will you. Whether it's complete or not, we don't know. What is sought to be conveyed is only according to the undivided interest. So the sale deed should be restricted only to that. Therefore, there's a transfer of. Then exclude all that from the deed. The problem is solved. Then you will never get the kata. You will never be the owner of the apartment. You are defeating the very purpose of. That is the. I have no problem. I am clear in my mind. I am clear in my mind that you are trying to purchase an apartment. What is the schedule? What is the schedule indicating such kind of transactions? No, in the stamp act. Every instrument coming within the description of the schedule, stamp act could be there. Yes. Section. Yes. You're reading the definition as prior to 2003. You're reading MN as it amended in 2003, correct? This was inserted in 2003. What was the provision prior to 1996? But I am clear in my mind that you take away Schedule B and ask him to reconsider with reference to Schedule A. You will not get the ownership of the apartment. You take that risk. The sale don't indicate only 134th or 150th share of the land, which you valued at 9 lakhs. On that you pay. You'll only get the apartment, which can't be the subject of that particular deed. I'll make that clear. Huh? Our calculation ಮೇಲೆ ಮಾಡಿದ್ರೆ ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. ಈಗ ಅವರು ಬರೀ ಅನ್ಡಿವೈಡೆಡ್ ಇಂಟ್ರೆಸ್ಟ್ ಮಾತ್ರ ಮಾಡ್ತಾರೆ. ಸೈಡ್ ಏರಿಯಾ ಪೂರ್ತಿ ತಗೊಳ್ತೀರಾ ನೀವು? What is the total extent of the land? 1560 undivided share. So 45 lakhs ಬರುತ್ತೆ. $35 lakhs according to them is the site area is 156.0.80 square feet at rupees 2050 per square feet. That is 35 lakhs. Built up area is at 350 per square feet at 8,90,000 plus 13% for amenities, 10 lakhs. Total is they have said that 1,560 square feet would be the undivided share. No. Virtual area built up is 2,545. The extent of land together would be a large sum. Are you saying that the size of the plot is only about 1,560 square feet? The entire plot? It's 30,257 square feet. We're not. Whatever is your undivided share, what was it that you agreed to purchase? What is the ratio? Agreement of sale is also for the concept buying of an apartment. Agreement of sale contains the apartment also is scheduled. No, because clause 2, page number 34. You have jointly entered into an agreement with Mr. So-and-so as developers for development of the Schedule A property into a residential apartment building with common areas. Whereas the purchaser agreed to purchase one of the units specified undivided share and has requested the builders to construct an apartment in the multi-story building proposed to be constructed in the Schedule A property, and for that purpose a separate construction agreement. So you first enter into the agreement with the builder. The vendor first enters into an agreement with the builder to construct. Thereafter, they come and agree to buy one of the apartments here. That is why even in the agreement of sale, there is a schedule indicating the apartment that they intend to buy. No. Kindly see clause 2. You have, if somebody has to build, why did you enter into the agreement? At page 34, clause 2. Whereas the vendors, you are the vendor. That is your vendors are the vendor. Whereas the vendors have jointly entered into an agreement with Mr. So-and-so for the development of the Schedule A property into a development of into residential apartment buildings with common areas and facilities wherein persons intending to own apartments can acquire undivided specified shares in the Schedule A properties with the right to construct an apartment. Why did you enter into the agreement then? No. Your vendors entered into an agreement with the builders to build. So therefore, why would you enter? That's why the agreement indicates. Therefore, the agreement, you are basically stepping into the shoes of a vendor to purchase the contract which you had entered in, which your vendor had entered into. So you are actually buying the apartment that he had ordered. Yes. Your vendors were the owners of the land. They entered into an agreement with the builder to develop. You under this agreement of sale agreed to buy one of the apartments that are constructed in the land owned by your vendor. Essentially, the agreement that you had entered into with the builder. So you are transferring that right. Which has already been entered into by your vendor under the agreement of sale. That right you are taking, because if you were to buy just undivided interest with a pre-existing agreement, you will suffer the consequence. Since you are taking the benefits out of that contract under this agreement of sale, including that apartment in Schedule B, you are bound to pay the value of the apartment as indicated by them. You cannot escape that. When do you want it? vacations. I can't give it to you.
Chetan Jadhav.
Lordship, with the kind permission, Your Lordship. Lordship, with the Lordship kind permission, serial number 23, today's list, Your Lordship. The state government is a party, Your Lordship. It is regard to Bane land. The petitioner has stated that the matter is covered and falsely taken an order of disposal, Your Lordship. It is not covered. In fact, there is a division bench, this thing, Your Lordship.
Sir, Shivanand said it is covered, therefore it is.
Your Lordship, it's not covered, Your Lordship. That's a false submission. In fact, she is herself a petitioner.
Government advocate made a submission. Why are your colleague made that submission?
Lordship, no, Lordship. Those Bane matters are specially assigned to me and by the department, and I am the advocate on record in that, Your Lordship. My name is shown in the cause list. They have wrongly shown that it is covered. It is not covered, Your Lordship. And in fact, yes, Your Lordship.
You should have given proper instructions, Shivanand. You told him it is covered, therefore he said it is covered.
No, I have not told him it is covered, Your Lordship. That is a false submission, Your Lordship. In fact, Your Lordship, the very decision which the Justice Nagprasan has relied is.
ನಾಳೆ ನೀವು ಕೇಸ್ ಕರೆದಾಗಿರ್ರಿ ದಯವಿಟ್ಟು. ನೀವು ಶಿವಾನಂದ್ ಮೇಲೆ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ನಾನು ಶಿವಾನಂದ್ ಕವರ್ಡ್ ಅಂತ ಹೇಳಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇಟ್ಸ್ ನಾಟ್ ಎ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್, Your Lordship.
Tomorrow.
Obliged, Your Lordship.
Lord, I appeal for the petitioner's counsel.
Yes, sir.
Lords,
Not the
respondent three, my lords.
Yes.
My lords, the senior counsel is not in station. He is before the Dharwad bench. So I'm seeking for accommodation, my lords.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
But the order of the government rejecting the sanction is under challenge.
After vacation ಬರ್ಲಿ ಹಂಗೆ.
Please, my lords.
ಮಾಡಿ. They're not asking for time. You want me to pass over, I'll pass it over. Pass over. ಶಿವಾನಂದ್ ಅವ್ರೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ, ಅವ್ರಿಗೆ ಹುಡುಗಲ್ ಅವ್ರಿಗೆ ತಕ್ಷಣ ಹೇಳ್ಬಿಡಿ. ಆಮೇಲೆ ಅವರು ಇಲ್ಲ, ಅವ್ರ ಕ್ಲೈಂಟ್ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬಿಟ್ಟಾರು, ತಕ್ಷಣ ಫೋನ್ ಹೇಳಿ ಅವ್ರಿಗೆ. ಒಂದ್ಸಲ ಹೇಳ್ಬಿಡಿ, ಆಮೇಲೆ ತುಂಬ ಕ್ಲೈಂಟ್ಗೆ ಹೇಳಿ, ಆಮೇಲೆ ಅವ್ರು ತೊಂದರೆ ಆಗದ್ ಬೇಡ. ಎಸ್. What is the next charge? Vacation. You want to continue with the next set of you.
Srimati Rashmi Jadhav.
What is the next charge? Ready na? Ready na? ನೀವು ಯಾರಿಗೆ? ಯಾರು R4 ಯಾರು? ಲಾಟಿನ ರೆಡಿ ಇಲ್ವಾ? To the next area. The loan was taken by CH-19 Enterprises. And you had given the fixed deposits as collateral security. In what way related to this? No, in what way are you related to this enterprises? In what way are they related to the deposits? Next year, A. Next year.
Page 10. BPL account number C-19 and C-20 memorandum of plan but you in favor of where the FSP improves security to attempt to realize now we have considered this they repeated memorandum of charge in being that liabilities are not paid.
This fixed deposit that they made in your bank, this original certificate is with you or was with them? Correct ಆಗಿ ಹೇಳಿ ನೀವು ಯಾರ ಹತ್ರ?
Then we are to pass certain order against
Synopsis. In the suit that you had filed against the borrower, you did not make them as parties. So when you filed the suit for recovery of the outstanding loan, did you set off this money that you had taken as security? Why? Why? No, you already had a fixed deposit in your favor. When you filed the suit on the boat being damaged, you were given a loan to somebody. That boat was insured. Boat met with an accident. You filed a suit against the insurer who repeated your claim. You did not make these people as parties. In the suit, you did not state that 4,75,000 fixed deposit is thus as a collateral security. Minus that amount, we are seeking for the balance. Then how can you raise this claim now? How can you justify that endorsement is now issued? If they had really given this FD as collateral security, why did you not set this amount off when you filed the suit? Suppose 6 lakhs was outstanding, 4,75,000 was already with you. You should have filed only a suit only for 1,25,000. Where did you say in the plaint that this was a collateral security available with you? Yargo potto yargo. If it's already here, I look at it. Why should you take the trouble of getting it? Iden hakid ನೀವು ದಾವ?
Only a claim you not towards what the law was allowed to give to yesterday. When you run
ಇಷ್ಟು ಜನ ಪಾರ್ಟ್ನರ್ಸ್ ಇದ್ರಾ? 20 ಜನ ಪಾರ್ಟ್ನರ್ಸ್ ಇದ್ರಾ? ಎಲ್ಲಿದ್ದಾರೆ? ಇಲ್ಲ ಫಸ್ಟ್ ನೀವು ಕರೆಕ್ಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಕರೆಕ್ಟ್ ಹೇಳಿ. ಅವ್ರ ಪಾರ್ಟ್ನರ್ಸ್ ಆಗಿದ್ರಾ? ಹರೀಶ್ ಕಾಮತ್, ದಿವಾಕರ್ ಕಾಮತ್. When you filed the suit, did you make them as a partner? No. Then why are you saying that they are the partners now? Then what is there to show that they had agreed as guarantors or as? I want to see your own document first. Let us see your plaint. Where have you said that you had a collateral security of 4.5 lakhs? The fixed deposits. And you have taken 6 lakhs from the insurance company also now. So in this, you have never said anywhere about the security, this collateral security of 4.75 lakhs. This suit was filed in 1993. When was this given according to Annexure R1? 19? Would you not have mentioned it as a bank? In your plaint, you should have said so, isn't it? That is a proof of the fact that. Annexure R1, na? Annexure R1. Now, please read Annexure R1. You shall stop there. Please, I hereby request you to enforce the security. If your attempt to realize the due from so and so by filing suit, obtaining decree and executing the decree against the borrower were not successful. Where have you said in the suit that in the event the suit fails, you still have the right to go against them?
However, it is not all.
ನೀವು ಇದು vote ಸುಟ್ಟೋದಾದ್ಮೇಲೆ we need to make the demand. ಅವಾಗ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಇದ್ರ ಬಗ್ಗೆ. ಮತ್ತೆ ಯಾವಾಗ ಗೊತ್ತಾಯ್ತು ನಿಮ್ಗೆ ಇಲ್ಲಿರೋದು? ಮೋಸ ಮಾಡಿದ್ದಾರೆ ಬ್ಯಾಂಕ್ ಅವರು.
ಈಗ ಏನಾಗಿದೆ ಕ್ಲಿಯಾರಿಟಿ ಕ್ಲಿಯಾರಿಟಿ since they cannot enforce it now, is it money is around still no 1 crore not changing there. But so if they
Show me the assignment. Show me the assignment deed. Your entire case appears to be false because you did not make this assertion. You should have, if the 6 lakh default occurred, you should have immediately issued a notice to them saying that when. So when you oh no ನಾನು ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡಾದ್ಮೇಲೆ ಆಮೇಲೆ ವೆಕೇಶನ್ ಇಲ್ಲ ಬೇಡ ನೀವು ಕೌಂಟರ್ ಹಾಕಿದ್ರೆ ಕೌಂಟರ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಿ you had, according to you, an agreement by which he had assigned the fixed deposits in your favor for the default of CH-19 Enterprises. Apart from annexure R1 and R2, there is no other document, correct? There are no other documents, correct? Now, on the default committed by that enterprises, when did you first issue a notice to them? It's already produced. You have filed your objections. Where have you said? So until then, you had never made a demand against them. Force it. Well, when is it? Can you do it without notice to them? Start by kindly vote 170. I can raise my, I can put notice. I can just. If you have a general lien over is their money, they are not the loanees. They are not the loanees. They have not borrowed a loan from you. You have no general lien over everybody's money. You have a general lien of over all the monies that are due to you from a person. They are not due any monies from you. Therefore, if I have to accept this memorandum of general lien, they should find a place after 1993 by issuing a notice to them. Last time, I did not issue a notice. I give a deputy to draft and get it followed. ಆಯ್ತು ನಾನು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಳ್ತೀನಿ ಕೊಡಿ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ ನಾನು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಳ್ತೀನಿ ಅಷ್ಟೇ ಅಲ್ವಾ page what do you want me to read? Page number 18. Yes. As a security for a legal vendor, that will be due to you, but the borrower and upon the bank guarantee we issue and you invoke, they invoke when the benefit is not for it all. These are the equality. There is no other way to become the security. As a security, the legal vendor, borrower, he is the password.
Even if your cash or estimation the time you can. I am fully personal and rebalance that. Right? The balance along or repayment any account even before the interest of interest may be allowed as per the bank and report. Even for the material value interest will and that's the and if the same deposit new or also can be continuing security for all outstanding amount. That's what it's all. Now he says now, for accounts interest of bank when it becomes payable, I forgot it clearly. When it is and all
So according to your objections, at page number 3, your objections, Sodhi, these respondents submit that lifetime of V. Devdas is common. Own matter, not these people, his father. But please read that. Please read that. These respondents submit that during the lifetime. Page number 3.
Yeah, this is one of the others being balanced with the efficient sense of data common. Both are businessmen location.
When was the loan given to them, that enterprises?
Well, can take the deposit maturity.
83.
I did not give you permission.
What?
Below of the objection statement. Whether government may go to deposit reduced billing, the first respondent have a right to see over the term deposit. First respondent refused to release the majority amount. It is more written document. First respondent stated in term deposit offer and granted the state loan. You have borrowed decision. Partners or a purchase decision could be taken to an accident. Both we never said, not the fancy document that is in there in that. That these documents, these amounts was given as a security to people now. I did not issue a notice, not it's not more than this. What we want is in a way, sanctioned.
You should have brought it. If you are arguing, you should have brought it. You can't, after starting argument, saying that there is that judgment, there is this judgment. I will reserve it. You file your written arguments. Or reserved. ನೀವು ಮಾಡಂಗಿದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇವಾಗ, ಇಲ್ಲಾಂದ್ರೆ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸಾಕು. What is the matter about? What is the next area? ಮೇಲೆ ಅಪೀಲ್ ಇದೆಯಾ ಇದ್ರ ಮೇಲೆ? ಕೊಟ್ಟಿರಲಿಲ್ಲ. ಓದಿ ಎಲ್ಲಿ ನೋಟಿಸ್ ಇಲ್ಲ ಅಂತ. Given objections, Alva. Priyaka. That's your mother, isn't it? Your mother. Agreement was in the name of the son. Sale it is in the name of the mother. Now under this order, who is to pay the stamp duty? Your mother, isn't it? The order prakara yaar katbek stamp? Where is the agreement? No, in a proceeding initiated against Satish only. ಎಲ್ಲಿ ಕೇಳಿದ್ರ ಅವ್ರನ್ನ? Where is he issued with notice? ಅಲ್ಲ ಇದು ಇದ್ರ ಪ್ರಕಾರ ಫಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 11 ಅದರಂತೆ ಶ್ರೀಮತಿ ಎಲಿಯಕ್ಕ ಕೋಮ್ ಚಿನ್ನಪ್ಪ ಪೂಜಾರಿ ಅವರು ದಿನಾಂಕ 19/12/2002 ಖಂಡಿತ ಕ್ರಯ ಚಿತ್ರೀ ಮಾಡುವ ಬಗ್ಗೆ ದಿನಾಂಕ 7/9/15 ಈ ಕಚೇರಿ ಕೆಳಕಂಡ ವಿವರಣೆ ನೀಡಿರುತ್ತಾರೆ. ಸತೀಶ್ ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಟಿಸ್. ದಿ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ಡ್. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಟಿಸ್? ಮೋಹನ್ ಕೊಟ್ಟ, ಲತೀಫ್ ಕೊಟ್ಟ. Proceedings were initiated against Satish and the vendors. Where have you issued notice to him? Mother was not even a party to the proceedings. Wapas kadisla. An order passed by the Deputy Commissioner calling upon the petitioner herein to pay a sum of rupees 6,03,454 as stamp duty is called in question by the petitioner. The allegation against the complaint was lodged by one KP Mohan against the petitioner K. Satish and another person called Latif, contending that Satish and Latif had entered an agreement of sale whereby Latif had agreed to sell the property bearing serial number 22/383 converted land 23/383 measuring 29 cents to Satish for a sale consideration of rupees 31,90,000 on 24/2012, and he had thereafter proceeded to execute a sale deed in favor of Satish's mother Eliaka for a sum of rupees 6,33,000 only on 19/12/2012. The complaint was that though the agreement of sale was for a sum of rupees 31,90,000, yet the sale deed ultimately executed in favor of Satish's mother was only for a sum of rupees 6,33,000, and therefore there was an attempt to defraud the state of the appropriate stamp duty. The impugn order indicates that the mother of Satish alone was issued with a notice, and she has given her explanation on 7/9/2015. Apart from Eliaka, the mother of KP Satish, the statement of the complainant and the vendor have been recorded, and on the basis of these statements, the impugn order has been passed. When the primary allegation of wrongdoing was against Satish, and when he was arrayed as the first respondent, it would be necessary, it would have been mandatory for the Deputy Commissioner to issue notice to Satish and thereafter proceed to consider the matter. So without following the set procedure, merely by relying upon the statement of the complainant and the ultimate purchaser, the impugn order has been passed. Since the impugn order directly affects the interests of K. Satish, the petitioner, and since he has not been heard in the matter, but the impugn order cannot be sustained. Though an appeal is provided against the impugn order, since the impugn order fundamentally suffers from a basic defect, in as much as the person agreed by the said order has not been made a party, it is necessary to entertain this petition, notwithstanding the availability of an appellate remedy. Consequently, the impugn order is quashed and the matter is remitted to the Deputy Commissioner, the direction to the Deputy Commissioner to notify the petitioner and thereafter proceed to consider the matter afresh. Contentions of either of the parties are left open. What is the matter about? What is your ground? Seven years. In ನೋಡಿದ್ರಾ ನೀವಿಲ್ವಾ ವೆಂಕಟೇಶ್ ಭಟ್ after vacation. matter ಕೇಳಿದ್ನ First. ಅಪ್ ಅಂತ ಆಗಲ್ಲ. ಅವತ್ತು ಮೆನ್ಷನ್ at 2:30. ಅವತ್ತು ಮೆನ್ಷನ್ ಮಾಡಿ.
Yes.
Who are you? I know. You're the petitioner, I know, but what is your status? What is your locus standi to challenge annexure A? Now permission is granted for opening of a pharmacy by a society. Correct. But what is your ground? Who are you to challenge it? So you are a rival, business rival. This is not a PIL. You have not filed the petition in public interest. You are saying that the permission granted by the government in respect of its premises to a society is illegal. Correct. The first question is, what right do you have to challenge that particular permission? In your house, if you are granting permission to somebody to do something. Stena. Did this court consider your locus when the earlier petition was filed? Where is it considered? Annexure R. No, in the earlier petition that you filed, where was the consideration by the court about your locus standi? Okay. Where did this court consider your contention, your locus to challenge the order? You are not answering my question. This court did not consider as whether you had locus standi or not. There was no consideration. That's why I said, suppose this court had held that you had the locus standi to question that. Yeah, you have come before this court, you have to satisfy him whether you have a right to challenge that. You are a rival trader, isn't it? The other citizen also has a right to survive, not just you. There's no monopoly by you. It's the government's premises. Who are you to question what they do inside? If they choose to give it to somebody, anything else, Jana? The petitioner is questioning notification dated 1/6/2017, by which the state has accorded exemption to the second respondent society to run a medical shop within the premises of the first respondent Mahatma Gandhi General Memorial Hospital, situated at Moodgere, Chikmagalur. The petitioner is running a medical shop adjacent to the government hospital, and he contends that by virtue of this exemption granted, his business would suffer and he would incur heavy loss. In other words, the petitioner is a rival trader who is aggrieved by the exemption granted to the Taluka Agricultural Produce Cooperative Marketing Societies to run a pharmacy within the premises of a government hospital. It is settled law that a rival trader does not have the locus standi to question the permission or license granted to another trader, merely because the petitioner would suffer a financial loss because of the opening of a pharmacy by the society. That would not confer a right on the petitioner to challenge the exemption granted by the state. It is to be stated here that the state which owns the hospital is at liberty to permit the running of a pharmacy unit of a person of its choice. A trader in the vicinity would have no right to insist that the government should not allow such units to be set up within the government hospital. Learned Counsel, however, submits that he had been permitted to seek for appropriate reliefs in the earlier round of litigation, which he had initiated in WP 54588/2018. And for the non-implementation of the order passed in the said petition, he had also initiated a contempt in which he had been granted liberty to challenge the exemption granted, and therefore he has the locus standi. It may be pertinent to state here that in the earlier round of litigation, this court did not consider the question of the petitioner's list, and this court only directed the state to take a decision as to whether the society would fall within the prohibited category as indicated in the notification dated 3/8/2011. In my view, the power to grant exemption would lie within the domain of the state government, and the power of the state government to permit the running of a unit within the premises of its hospital cannot be challenged by a rival trader. I find no merit in the petition. The petition is therefore dismissed. I'm not on the merits. I can't even allow you to question this. If you have the locus, then I'll go into the merits. If you have no locus, I will not go into that at all. It is their business. If they're committing an illegality, you know what else will be done. So suppose one more private trader opens a shop next to your shop. You can go to the municipality and say, don't give him permission. Hey, ಅದೇ ತರ ಆಗಿದೆ ಕೊಡಿ. You are for? What is this petition about? You are for the wife. You are for the wife. What is the order that is challenged? Petition. Thirteenth. This was a case in which they wanted to surrender the license. When were you lease the property? No, from. is this letter dated 15/7/2017? This is the one. 18,53,000. Where is this 2011/2012? 23,60,000. In your synopsis, you have referred to 2011/2012. Then your synopsis is not page number 2. You had filed WP 3452 of 2013. You have accepted the earlier order. Now you are asking for. So now the present demand is only based on the CAG report. Now, how can you rely upon the CAG report to come to this conclusion? Hello, Tidra. What is annexure D? This is the renewal. Now this annexure D. When was it increased at 5,000 rupees a month? From 2001. So from 1799 till 17/2014, it was at 4,000 per month. From 17/1999, for a period of 15 years, it was fixed at 4,000 per month. Then what is the other increase? ₹5,000 ಯಾವಲಿಂದ ಆಯ್ತು? ₹4,000 ಇದೆ. Annexure D ನೋಡಿ. Tiptoe Township ಸೋನ್ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ನಂಬರ್ 24/2001 1799 15 ವರ್ಷಗಳ ಅವಧಿಗೆ ಗುತ್ತಿಗೆಯನ್ನು ನವೀಕರಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿ 99ನೇ ಸಾಲಿನವರೆಗೆ ₹4,000 ಎಂದು ನೆಲಬಾಡಿಗೆಯನ್ನು ನಿಗದಿಪಡಿಸಿರುತ್ತಾರೆ. ದಟ್ ಇಸ್ ಅಪ್ ಟಿಲ್ 1999. 2000ನೇ ಸಾಲಿನಿಂದ ನೆಲಬಾಡಿಗೆಯನ್ನು ನಿಗದಿಪಡಿಸಲು ಅಂದರೆ 1799 ಸರ್ಕಾರದ ಆದೇಶವಾಗಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ವಿನೋದ್ ಚಿತ್ರಮಂದಿರದಿಂದ ₹5,000 ಮಾಸಿಕ ನೆಲಬಾಡಿಗೆಯನ್ನು ವಸೂಲಿ ಮಾಡಿ ದೇವಾಲಯದ ನಿಧಿಗೆ ಜಮಾ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಸರ್ಕಾರಿ ಆದೇಶದ ಮತ್ತು ಕ್ರಮ ಸಂಖ್ಯೆ ನಂಬರ್ 3 ಪ್ರಕಾರ ನೆಲಬಾಡಿಗೆ ಮತ್ತು ಗುಡ್ ವಿಲ್ ನಿಗದಿಪಡಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಸರ್ಕಾರಿ ಆದೇಶ 11/4/2001 ಗುತ್ತಿಗೆ ನೀಡುವ ಬಗ್ಗೆ ಹೊಸದಾಗಿ ಮಾರ್ಗಸೂಚಿಗಳನ್ನು ರಚಿಸಲಾಗಿದೆ. ಇದರ ಪ್ರಕಾರ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕೆ ಗುಡ್ ವಿಲ್. Where is this? Once you agree for renewal for 15 years, then how can you impose goodwill in the middle? ನೀವು ಸರೆಂಡರ್ ಮಾಡಿದ್ರೆ ನೀವು ಇಟ್ಕೊಂಡಿದ್ರೆ ಏನು? ಯಾವಾಗ? Is it the fact that they have surrendered? ಎಲ್ಲಿದೆ? Where have you said that they have surrendered? Next year? Where do they admit that they have taken possession? ನೀವು ಸ್ವಾಧೀನದಲ್ಲಿ ಇನ್ನೂ ಹಂಗೆ ಕಂಟಿನ್ಯೂ ಆಗ್ಬಿಟ್ರೆ? Where have you said that you have surrendered possession? ಎಲ್ಲಿ ಹೇಳಿಲ್ಲ that you have taken possession ಅಂತ. Where have you said in your petition that you have surrendered? ಎಲ್ಲೂ ನೀವು ಅದನ್ನು ಎಲ್ಲೂ ಹೇಳಲ್ಲ ಸ್ವಾಧೀನ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ. See, by virtue of this 24/8/2001 up to 2014, You can only demand a rent of 5,000 per month. You cannot ask for. The petitioner is calling in question the communication dated 15/7/2017, by which the petitioner has been called upon to pay ground rent of rupees 18,53,000 for the period commencing from July 1999 till March 2012. This communication appears to have been addressed pursuant to have certain objections being raised by the auditor Bharata Lekkapari by the controller of accounts. It is not in dispute that on 24/8/2001, the lease agreement was renewed for a period of 15 years with effect from 1/7/2099, and a ground rent of rupees 5,000 was paid. In the light of this particular government order, the state cannot demand rents in excess of rupees 5,000 per month, notwithstanding any audit objection that may have been raised. The petitioner also claims that they had addressed a letter to the deputy commissioner stating that they are unable to run the theatre, and it was necessary that the possession of the property be taken over. In the communication dated 10/5/2012, addressed to the deputy commissioner by the commissioner of the charitable endowment, Hindu charitable, religious and charitable endowments board, it has been acknowledged that the petitioner had agreed to give up the property, possession of the property, with effect from 1/3/2012, and therefore it was necessary that the possession of the property be taken over after calculating the arrears due till 29/2/2012. It is also not disputed that a major portion of the theatre has also been acquired for the formation of the road. In the light of the fact that the government had fixed the ground rent payable at rupees 5,000 per month for the period commencing from 1/7/1999 till 1/7/2014, the petitioner would be liable to pay rents only at the rate of rupees 5,000 per month till the possession was handed over. In that view of the matter, the impugned order is quashed, and the authorities are directed to recalculate the arrears, if any, due at the rate of rupees 5,000 per month till the date the possession was surrendered by the petitioner or the possession taken over by the department. ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರಲ್ಲಿ ಯಾರಿಗೆ ಮಾಡಿದಾರಾ, ಎಲ್ಲಿ ಮಾಡಿದಾರಾ? The sum of rupees 4,63,250 deposited by the petitioner by the demand draft pursuant to the interim order granted by this court on 12/12/2017 shall also be taken into account and due deductions be given to the said amount. Diversion orders. Dina? What is the reply in their objections? ನೋಡಿದ್ದೀರಾ ಜಜ್ಮೆಂಟ್ ನೋಡಿದ್ದೀರಾ? ಇದಕ್ಕೆ ಹಾಕೊಳ್ಳೆ ಲಾಫ್ಟಿಫಿಕೇಶನ್ ಹಾಕೊಳ್ಳೆ ಯಾವ್ದು ಹಾಕೊಳ್ಳೆ?
Court officer, sir. Court officer, sir.
ಹೇಳಿ ಮೇಡಮ್.
Sir, serial number 44 ಏನಾಯ್ತು?
After vacation.
After
Sir,
vacation.
serial number 39.
Thank you, sir.
19th ಗೆ.
Thank you, sir.